And go ahead and get started with our Education Tuesday. And then we have a few Zoom participants, so we're just welcoming them. And we have our wonderful Nate here to talk to us about small business employment law. So I'll hand it right over to him.
All right. That's lovely when you get to look at the screen and you see you and drive yourself. That's awesome. So, all right. Well, here's how I got to you all. So I've had the pleasure of having Michelle, as we were just discussing this paradigm. It seems very possessive. Michelle has been my realtor for a long time. She helped us sell our first house and buy our current house. So got to her, and then I need your birthday again, and here I am. So I know we have mostly realtors in the group, and then some non-realtors. Is that right? Who do you guys work for?
OEM Bruxton's Garage.
Okay. Okay. Excellent. And everybody else is in real estate? In some form of fashion? Yeah, you're like the expert. Yes. Okay. So I just actually launched my own HR consulting firm in December. So it's pretty fresh for me, about 3 or 4 months in, and just happy to be here and share some insights around employment law. I know that each of you in various forms and fashions obviously are dealing with employees, contractors as well. And there's just a lot that really, as you probably know, a lot that goes into having employees and just making sure that you're compliant with all the laws that apply to having staff. So, all right, we could just jump into the presentation. We have somebody with amazing clicking skills here today. Her name is Michelle.
She's starting off strong.
She's starting off strong. So we set you up to fail. Yeah. All right. So today's presentation is stay compliant, stay confident, mastering employment law basics. We're not going to cover, everything under the sun, but I will touch on the things that I think are most pertinent to you as small business owners. That's your quick. It's full. Well, all right. I'm going to quickly read you this disclaimer. So the information, recommendations, and guidance contained within this presentation are for general HR and compliance purposes only and do not constitute legal advice. I'm not acting as an attorney, and no attorney-client relationship is created through this training. And then for advice regarding the interpretation or application of any law, regulation, or legal requirement to your specific circumstances, I do recommend that you consult with your qualified legal counsel. All right, on to more interesting things. So let's kind of set the foundation here for why employment law matters. First, it's an opportunity when you are compliant with and understand the law. It's an opportunity to protect yourself from costly lawsuits. And we'll talk here in just a couple minutes about an example that is a bit of an anomaly. It's a bit larger than many. But when you are not understanding employment law and complying accordingly, you could end up with some very costly lawsuits. Also, it's obviously a good idea to ensure consistent and fair treatment of employees. The one thing I would say here is sometimes I have clients who get kind of worked up about having a handbook and having documented policies and procedures because they say, well, we're kind of locked in. Like if it says it in the book, like this is exactly what we have to do. And yes, you do want to use your handbook as a resource, as a tool, but the reality is, in my opinion, handbook policies are really just parameters, providing some guidelines on what should be done. But the reality is like every employee is different. Every employee comes to work with different circumstances. Handbooks to me are really an opportunity to say, here's the baseline, here's how we're going to be as consistent as possible and as fair as possible, but we may have to do something different for this employee than another. Obviously, you want to be thinking about establishing precedent and those kinds of things, but having the ability to be flexible with your policies, I think is really important. Building trust and organizational reputation. Trust me, like the word gets around when you are not being consistent and fair as an employer. We all probably know what Glassdoor is. When you start to not really abide by the law or kind of get squishy with your application of your policies, that word gets around, people leave your organization, and it's only a click. It's only an easy click for a former employee to go to Glassdoor and say, man, this organization really stinks. And then employment law helps small employers and nonprofits avoid common compliance mistakes. So I'm again not going to touch on all of them today, but I think there are some pretty basic mistakes that can be made simply because you just don't understand the law. So we'll talk about some of those. You're doing great, Michelle. Thank you. All right. So as I mentioned earlier, just wanted to touch on a court case that I think highlights one basic mistake that was made by an organization that resulted in a pretty significant cost to that company. This is out of California, and I feel like anything out of California is always more extreme, especially when it comes to employment law. So I wouldn't necessarily anticipate this happening here in Pennsylvania, but it could. So in this specific example, this organization, it's TLC Home Care Services. So they're basically employing people to go out into homes, providing personal care and whatnot. What they did is they classified all of the individuals working for them as independent contractors. And listen, a lot of you have independent contractors and you're totally fine. Like they all meet the criteria, it's legitimate. In this case, they were sending people out into homes with supplies that were provided by the company. They had to abide by a whole plethora of company policies. They had to report in on a regular basis. There was a lot of direct supervision. There were a lot of things that really made them appear to be employees and not independent contractors. And really they were functioning as employees, but not getting paid properly. So therefore not eligible for overtime, eligible for paying into taxes and those kinds of things. In this particular case, they were paying $120 for a 24-hour shift, which when you take 120, divide by 24, you get $5 an hour. It's not minimum wage anywhere, and it's clearly not minimum wage in California. So they were violating the minimum wage law as well as the FLSA, which has to do with classification of employees. So as I said, they did not meet the qualifications to be classified as contractors. There was a $10 million judgment against the company. And as a home care agency where your margins are pretty small to begin with, you don't easily absorb a $10 million judgment and expect to stay in business. So this company is no longer in business. So again, a bit of an extreme example, but I think it does highlight that a small mistake can really have big financial consequences for the organization.
Can I ask you a question?
Sure.
Maybe you get to this, maybe I should ask you a question. Where did we find, you said it did not meet qualifications to be classified as contractors? How do we know what those are?
We're gonna get that on slide 8, I think. I'm not sure exactly where it is, but definitely we'll touch on it. Yep. Nice segue. All right, so from a legal hiring perspective, a couple of things I wanted to note here. When you're hiring and you're building your job descriptions, you really want to focus on the essential job qualifications and the essential job duties. Over the course of my career, I've seen a lot of different job descriptions. Some companies tend to put like everything in the kitchen sink into the job description. Some of them kind of tend to be a little bit kind of fluffy or kind of like not really sure exactly what the person's supposed to be doing. What I recommend is really when you're writing that job description, focus on what are the core functions? What is exactly that you need the person to do? And so kind of focus your time there. Avoiding protected class functions. So protected classes would be things like race, age, gender, sexual orientation, those kinds of things. When you're in the hiring process, you want to make sure that all of the questions that you're asking are really relevant to the job at hand. When you're asking questions that relate to some of those protected classes, it really has nothing to do with the job. You're not really learning anything about the candidate that helps inform your decision as to whether or not they can do the job itself. I did want to share with you a couple of questions that may or may not surprise you as to whether or not they are okay. So first one would be asking, what is your immigration status? Okay, it sounds a little bit kind of benign, right? And you can ask the question, are you legally authorized to work in the US? And then they can share with you, what their immigration status is and whatnot. But coming right out and saying, what is your immigration status? You're targeting a particular characteristic. Will your religious holidays affect your ability to meet the work schedule? Now, you're kind of making an assumption at this point because they probably haven't told you what their religion is. You're probably making an assumption about what that religion is. Now, you can ask a question along the lines of, is there anything that would impact your ability to come to work within the schedule that we have? Have you ever filed a workers' comp claim? You guys work in the repair business, right? Like workers' comp is probably a thing at times. It's not okay to ask about workers' comp history because basically you're delving into medical history, which is a protected characteristic. I get why you'd want to ask because oftentimes if somebody has had a claim, there's a good chance they'll have a claim in the future, but it's kind of a heads-up question. And last one, I don't think people would ask this, but do you plan to have children? Now, I kind of understand like why you might want to ask it, especially as a small business owner, as you're like, well, we only have like 3 people, and if one person is expecting and they're going to be out for a while, like how are we going to staff the business? Again, it's not relevant to the job. And the reality is like if you decide to hire that person and they're either expecting at that time or they become pregnant in the future, it's really your job as the business owner to figure out how you're going to staff it. So just a couple of examples of not certain questions. And then just being consistent in your interview processes. Not to say that you can't ask different kinds of questions of different candidates as they come in, but I think having a standard interview questionnaire helps establish a nice format and rhythm, and it allows for that consistency. Now, obviously, you're going to engage in a conversation. If you're asking questions and they offer some information, you want to ask appropriate questions, certainly do that. And then documenting your hiring decisions. It's like anything else. I'm sure in real estate, like it's all about documentation, right? I know I signed a lot in papers when I bought my house. Same thing in employment, right? Like document what your hiring decisions are in the event that you end up in a situation in the future where you have to defend that decision. Right. Couple of thoughts on background checks. It's really important to follow the same screening process for all of your applicants. So if you decide that you're going to do criminal background checks, either because it's required in your industry or because you want to do them, because you're concerned about their interaction with clients or interaction with children, those kinds of things, whatever you decide to do, make sure that you're following that same screening process for all your applicants. Use the background check processes only when relevant to the job. So I wouldn't necessarily recommend that you do criminal background checks for a job where it's not really relevant. A, it's kind of a waste of your money. And B, you're not really learning anything that's going to shift your decision on whether or not to hire that person. Specifically with credit checks, I would highly recommend that you only do a credit check if the person is going to be working with money or financial transactions or has the opportunity to kind of finagle funds that. And then the last thing is when you're doing background checks, you have to make sure that you're following all of the requirements under what's called the Fair Credit Reporting. Now, some people think because it has the word credit in it, it only has to do with credit checks. It actually governs all background checks. So if you're going to be doing a criminal background check or child abuse history clearance or anything to kind of check the background of somebody, including credit checks, you want to make sure that you're providing the appropriate disclosure that you are going to be doing that check, that you get consent from them that you are going to be doing that check. And there's also, if something comes back in the background check that is questionable that you want to ask the person about, there's an adverse action notification process that you're supposed to follow under the Fair Credit Reporting Act. There's something called the pre-adverse action and then the adverse action. Pre-adverse action is like, hey, I want to hire Michelle. She's got something in her background check. I have to notify them that there is this thing that we want to ask them about, give them an opportunity to provide mitigating information, help us understand, is this really a concern or not? And then if you still decide that whatever Michelle did in her past is like not a good thing and we don't want to hire her, you then have to give her an adverse action notification. So there's, from the point of disclosing to them that you're doing background checks, getting their authorization all the way through to that adverse action process if you needed it. Really importantly, you kind of check those boxes in that process. Yeah, Karen.
Does that go for employees as well as independent contractors?
That's a good question. I'd have to double check. I don't think it would apply to contractors because it's a totally separate bucket. Yeah. Okay. I-9 verifications does not apply to contractors, but does apply to employed staff. So the I-9 is basically the form that you would complete within 3 days of hire. that essentially the individual is demonstrating that they are verified to work in the United States. Most people will give you a driver's license and social security card. Some people might give you a passport. Other people might give you a green card or something along those lines. There's very specific lists that you have to follow as far as like what's acceptable documentation. A couple kind of specific notes on the I-9s. Oftentimes, I will see employers take photocopies instead of originals. Under the USCIS, the immigration agency, you are supposed to be inspecting originals of those documents when filling out the I-9 form. Now, in this day and age, when we have such a scattered workforce, remote workforce, not a problem. There is a process by which you can do I-9 verifications remotely. It actually involves sitting in front of the screen, having them show you the documentation, but also mailing you the hard copy. So you have a hard copy in hand and a visual identification. But it also requires you to use something called E-Verify. So E-Verify is a system that all federal contractors have to use, but it's also a system that has to be used if you're going to be doing remote verifications. I've done a lot of I-9 audits in my past. Lots of times there's different fields that people don't fill in, missing signatures. It's not really a hard form to fill out. It's very self-explanatory, but a lot of things get missed. And the last thing you want to do is have an immigration auditor walk into your workplace and say, show me your I-9s. And you pull out these I-9s that have missing signatures or missing dates or those kinds of things. And then this doesn't happen very often, but sometimes you'll get new staff that will bring you a documentation, which is an acceptable form of documentation, but it has an expiration date. Not like a driver's license, those kinds of things. But if they're presenting like a visa document or something along those lines that has an expiration date, you want to have a tracking mechanism in place to make sure that you're keeping up with that you're aware of when those documents are expiring. So you can have that staff re-verify once the expiration date comes and goes. All right, so remind me of your name again?
Drew.
Drew. This is going to answer your question.
Yep.
So, and I think this is the reality in real estate where we have contractors and employees pretty commonplace. So the Department of Labor uses something called the economic realities test to determine if an individual should be contracted with as a contractor or as an employee. And we're going to talk on the next slide about kind of what that economic realities test is. But there are very, very specific criteria that have to be met in its totality to say, like, yes, this person can be a contractor versus no, they really should be an employee, W-2 employee. I don't know if we really have anybody in the group that's using volunteers, so I'm not really going to touch on this. But organizations, specifically nonprofits that have volunteers, they have to be really careful about having volunteers do poor paid work, basically doing work that employees typically would do and then not paying them. There's very specific requirements that have to be met in that realm, but that's only part of this group. So let's move on to the next slide.
Where would we find that information for the volunteers?
Oh, for the volunteers? I can send it to you. Yeah. There's I don't know off the top of my head, but I'm sure under the FLSA, like Department of Labor, there's very specific volunteer requirements. Do you have volunteers?
We have a nonprofit
Okay.
that has a board and there's a board paid position. And,
Okay.
And then everybody else who's a board member, I guess
Sure.
would be considered a volunteer.
Sure. Yeah.
And so I would wonder about that.
Yeah, board members I wouldn't be super worried about because typically there's a ton of boards that have volunteers, right?
Mhm.
I'd be more concerned about the staff level volunteer who's doing work that maybe there's also somebody doing that same work but getting paid for it. Are all your volunteers board members?
Yes.
Okay. I wouldn't be so much concerned about it. It's really more at the staff level where they're actually doing work and not getting paid while somebody else is getting paid to do the same thing. Yep. So for the economic realities, there's basically 6 things that the Department of Labor is going to look at to determine is the person properly classified as a contractor or an employee. Does that person have an opportunity for profit or loss? So in the course of their work, do they have the opportunity to make money? And do they also put their finances at risk and potentially lose that money? Whereas when you're working for a company, I mean, obviously you could get fired and lose money, right? Or you could get promoted and make more money, but you don't have that same level of control over that opportunity for profit. Investment in facilities and equipment. This is a big one. So I think I mentioned with that home care agency, they were supplying all of the materials, the resources, all of the things that those caregivers needed to do their jobs. When a company does that, that looks more like an employee than it does a contractor. Contractors typically are using their own laptop, their own office supplies. There can be a little bit of a mix, a carryover there, but generally, if the company is providing you with everything that you need to be able to do your job, that's more of an employee than a contractor. The permanence of a work relationship, the longer that you go as a contractor, the more it looks like maybe you should be an employee. Not to say that you can't be a long-term contractor, because again, they're going to look at all 6 things. And they're not going to look at each one individually. They're going to look at all 6 and decide overall, is the person a contractor? The nature and degree of control. So contractors typically have a lot of autonomy, independent discretion. They kind of set their own hours, kind of do their own thing. They might work within like a general framework, which I'm sure is true of real estate agents. But in general, like they're pretty autonomous and independent. So that nature and degree of control is going to be the difference too. Then there's some smaller categories. Is the work performed integral to the business? So what that basically means is, are these people working in positions that you typically would find in most companies? And then specialized skills required is also something that they look at to determine, is it a contractor or is it an employee? So again, they're not going to look at any one individually. They're going to look at all 6 in its totality to determine, if the person is classified correctly. Wage and hour. Ironically, minimum wage laws really aren't that much of a thing anymore because the labor market has shifted so much that like nobody pays minimum wage, right? At $7.25 in Pennsylvania, I'd be hard pressed to find an employer that's paying $7.25 and actually being able to hire staff. It's important to be aware of what that wage is that you're paying, at least that amount. And then calculating overtime. So for those of you who have staff who are paid on an hourly basis, not your contractors, but your actual W-2 employees, you want to make sure that you have established a designated work week. That could be Sunday to Saturday. It could be Saturday to Friday. It could be Friday to Saturday, whatever you want it to be. A huge misnomer often is that overtime is calculated within the pay period. Now, a lot of companies will pay like every 2 weeks or twice a month, that kind of thing. Overtime is looked at every week. So even if you're paying bi-weekly, you have to look at overtime eligibility of anything over 40 hours in a 7-day window. So again, if your 7-day window is Sunday through Saturday and the person works 41 hours in that 7-day window, you're going to owe 1 hour of overtime. You can't look at it over the 2-week baseline. Accurate timekeeping is a must, and salary doesn't automatically mean exempt. So what I mean by that is you've got exempt and you've got non-exempt. Exempt typically is your salaried staff. They're paid a fixed salary, right? They're not eligible for overtime. Non-exempt is going to be your hourly eligible for overtime. What I mean here is you could actually pay somebody on a salary basis, but they're actually a non-exempt. So here's an example for you. So maybe you have an administrative assistant. Typically, those jobs are going to be non-exempt hourly, okay? But you could decide for simplicity that you're just going to pay them on a salary basis. Not a problem. It makes things more simple, except for the fact that you still have to track their time because they're non-exempt. And so then if they go over that 40 hours and say it's $1,000 for 40 hours, they go over the 40 hours, now you're going to end up owing overtime. And so you have to know the hours anyway. So I typically don't recommend if you're going to pay somebody on a salary basis that you do at that time. Okay, so exemption testing. So I just mentioned exempt versus non-exempt, right? So there's a couple things that have to be met for somebody to be able to meet the exemption status under the Fair Labor Standards Act. So the first thing is the person has to make at least $684 a week, which currently equates to $35,568 annually. If the person doesn't make that amount, at least that amount on a weekly basis, they cannot be considered exempt or salaried. It's just not possible. So that's criteria number one.
Wait, they cannot be. Can you say that word?
Sure, they have to make at least that amount to be considered exempt. Yep. So if they're making $683 a week, just by virtue of their salary, they would have to be non-exempt. So that's criteria number one. There's also something, this is kind of the bigger part, is the job duties test. So actually, Michelle, if you want to go to the next slide. Oh, sorry, go back. I guess it's not there. Okay, true. Okay. So let's just say you have, X job and they make exactly $684 a week. You're like, oh, that's great. They can be salaried, except for the fact that you also have to run the job duties tests. So there's a couple different exemptions under the law that have to do with what is the scope of the work, what is the person focused on day in and day out that also allows them to be paid exempt salary. So there's a couple different categories. There's the executive exemption. So this is going to be somebody who supervises at least 2 full-time employees and somebody who has genuine authority over the hiring, firing, promotion of other significant personal positions. So you could have somebody with the title of manager, and I think this is a misnomer. You could call somebody manager, whatever, but if they don't have at least 2 full-time employees, and if they don't actually have any authority to hire, fire, promote, they cannot be exempt salary. The title alone does not dictate that. But the first one is the executive exemption. Second one is where a lot of jobs actually fall. This is the administrative exemption. So this is going to be people who perform office or non-manual work. So it's going to be positions in like HR, finance, compliance, IT, those kinds of positions. But the key here is the person in these jobs has to be able to exercise significant independent discretion over the work that they do. So that'd be another exemption category that would allow you to pay somebody's salary. And then the last one is the professional exemption. There's the learned profession. So this is going to be like attorneys, sometimes nurses, pharmacists, people with advanced education that could allow you to pay somebody on a salary basis. And then there's also creative professionals. So this is going to be like writers, designers, musicians, people who fit into those kinds of positions also could be considered exempt salary. So if you have somebody who's making less than $684 a week, they're automatically non-exempt hourly. If you have somebody working or making $684 or above, but doesn't fall into the executive, administrative, or professional exemptions because of the work that they do, they will have to be classified non-exempt. And it sounds super complicated. It's not. There's a pretty quick kind of duties test that we can run through on a position to identify, do you have that person classified correctly? All right. Common wage mistakes. So off the clock work. So sometimes you have like that high performing, non-exempt hourly employee that's like, I just love my job and I will do whatever it takes and I don't need to be paid for anything over 40 hours. It's totally fine with me, whatever. You cannot not pay a non-exempt employee for working. So you can't allow that off the clock work time. Sometimes you get the employees that are maybe not like super motivated to work for you, but super motivated for overtime, right? And so they just go ahead and work the overtime without authorization. The sad reality is when you do that, or when that employee does that, they've worked that time. So you do have to pay them for the overtime. Does that mean that you can't then discipline them for that, for not getting proper advance approval? No, you certainly can do that, but that's a performance issue, not a compensation issue. So off the clock work is not okay. Not paying for training or travel. So again, this is all going to be specific to your non-exempt hourly employees, right? If you've got your exempt salaried person, you're just paying that straight salary, no big deal. It's a lot easier. This is just for your hourly employees. So there are very specific requirements around when you have to pay for training time. Now, the reality is most training is going to occur during the normal workday, right? So you're already paying them anyway. But sometimes people will go for training opportunities outside of the normal work schedule. And there are times where that training time is required to be compensated. So when it has to be paid for, or when it doesn't have to be paid for, is if the person is attending the training truly on a volunteer basis, like it's not a requirement of their job, it's not at your suggestion, you don't have to pay for that training time. You do want to make sure that whatever training that they're going for is not directly related to their job, for it to also not be compensable. You want to make sure that there isn't productive work that's being performed during the training, because if they're actually doing work while at a conference, that is compensable time. So there are just some very specific nuances to be thinking about when you send somebody for training outside of the normal business hours, because it could actually be compensable and drive up your labor cost. And then travel. I don't know exactly how this would pan out in your world, because I know you have a lot of contractors, but again, let's just say you have a non-exempt hourly employee who travels during the workday. Typically, all travel time that occurs during the workday is going to be compensable. So if you've got, say, I don't know, an associate realtor that happens to be a W-2 employee and they're going from client to client, you want to make sure that their travel time is actually compensated. Now, there are very specific rules around that. If they have a break that's longer than 20 minutes in between clients, that isn't the result of the schedule that you set for them, there are some opportunities for you not to pay them, and it can get a little bit kind of complicated. But in general, any travel time that happens during the day is to be compensated, which seems kind of crazy, right? Because it's like they're not really doing anything productive. But if you think about it, they're actually traveling to and from these sites because of the work that you require them to do. Auto-deducting meal breaks, never a good idea just to kind of say like, okay, from 12 to 1 every day, we're going to deduct off an hour, because you never know, like maybe that employee is actually going to work through that lunch hour, right? And if they work through their lunch hour, like, yes, they might be eating at their desk, but they're also doing emails and whatnot. That's compensable time, so you have to be careful with that. And then treating exempt employees as non-exempt workers. So what this typically looks like is you've got an exempt salaried employee who maybe came in late one day for whatever reason. You can't dock their pay for that. Now, if it's an ongoing issue where they're not coming to work on time, you can address that from a performance perspective, but you cannot actually dock their time because it makes them look like non-exempt employees. You also generally should not ask them to track their time. So there are organizations like attorneys will have their salary workers track their time, but that's because of billable hours. Generally speaking, if you're asking your salaried employees to keep a time record, it makes them look like non-exempt employees. And if it ever were to come up in a claim, the DOL would probably say, like, you treated them as a non-exempt employee, they should have been non-exempt, and now we have to go back and calculate it over time. That was potentially owed to them. Okay. So just some kind of key policies to think about. I don't know if you all have employee handbooks or whatnot, but I think these are some of the key ones to think about, including you want to have policies around anti-discrimination and harassment, attendance and leave policies, appropriate use of technology, certainly confidentiality, a code of conduct, and then complaint reporting. And if you're ever in need of like a sample policy on something, you're like, I don't really know where to start with this. I know Brittany asked me for one recently. I can certainly give you a sample to work from, a template to use. So if you're ever struggling with that, just let me. I mentioned before anti-discrimination laws. Basically, this just kind of lists out some of the protected classes that are relevant to the workplace. So you've got things like race, color, national origin, sex, gender identity, and sexual orientation or gender orientation, religion, age, disability, and pregnancy. It's pretty far reaching, right? And you just have to be careful in all of your employment practices that you're not focused on those things. This is the easiest thing to think about. That you're not focused on those things, you're really focused on the job at hand. Does anybody in here have more than 15 W-2 employees? So I'll just touch on this briefly. When you have more than 15 employees, you're then subject to something called the Americans with Disabilities Act. which basically requires you to provide reasonable accommodations for employees. So maybe that's a modification to technology, or maybe it's an accessibility issue, or maybe it's a change in schedule. Lots of different things that allow an individual with a disability to perform the work that they do in light of their disability. So that's 15 plus employees. Any of the other protected classes, you only have to have one employee to then be responsible for making sure you're making accommodations. So the easiest one to kind of reference here is going to be religion, right? So if you have one W-2 employee and you have an employee that is of a certain religion and needs a potential accommodation around, say, a schedule change, or maybe they have a certain head covering that they wear, or maybe they need certain times during the day for prayer time. Those are the kinds of things that you'd have to think about, dialogue with that employee and say, how can we reasonably accommodate you? Now, just because an employee asks for something due to a protected class doesn't mean that you have to provide it. The only thing the law requires you to do is to engage in that dialogue with the individual to say, tell me more about your disability and tell us how we can accommodate you to be able to meet that disability or help you out with your protected class. So in that example, so say you have somebody who needs regular prayer times during the day. That's probably not a hard accommodation to make. They probably only need 5 or 10 minutes. They might need a private space. Maybe they already have an office. Great. Maybe they don't have an office. Maybe they're a cubicle dweller. But can you provide a dedicated space for them? I think sometimes people get really worked up about accommodations. It's like, oh my gosh, it's going to be a big deal. Lots of times these accommodations are very, very simple and very cost effective. Now, organizations, like I said, if it's going to create an undue hardship on the business, which could be an undue financial hardship, like let's just say somebody needs some sort of significant technological change to the technology that they use and the business really can't afford it, you can turn that person down. Or let's just say you have, let's go back to the religion example, maybe somebody needs off every Friday for some religious reason, but maybe you only have a handful of staff, right? And having that one person out every Friday is going to create an undue hardship. You could say no in that example. The bottom line is you have to be able to and be willing to engage in that dialogue to talk about, can we do this? And if the answer is no at the end of the day, not a problem, but you want to be able to say that you did have that conversation and looked at all possible options. Preventing and promptly addressing harassment, this is a big one. I think sometimes we have employees that come and say, I'm being harassed, there's this situation that's going on, I don't feel comfortable in my environment. And sometimes, I think the tendency is to say like, oh, this feels kind of like a big conflict, it's kind of sticky and I don't want to deal with this. So you kind of like don't address it, or you maybe kind of poo-poo it. But the important thing to know is that if those situations come up, it is your responsibility as the manager to at least look into it. Now, it could be that you look into it, you do your investigation, and you realize this really isn't a situation that rises to the level of harassment. Maybe it's just a personality conflict, or maybe you dig in deeper, you do your investigation, and you're like, there really is something here, there's something about this. The most important thing is just to make sure that you are, when those things come to your attention, that you actually address them. Sometimes you have employees come to you and they want to just tell you about a situation that's happening that probably is harassment. And then they're like, but I don't want you to do anything about it. Kind of puts you in a bad spot, right? But the reality is you do have to do something about that, because they have come to you. It is your responsibility to create an environment that is free from harassment. So in that situation, you're going to tell the employee, I appreciate the perspective, but we do have to look into this further. Obviously, we'll try and protect your confidentiality as much as possible. And it's important for us to get to the bottom of this. And then avoiding retaliation. Making sure that that employee that comes to you and says, I have a harassment situation, that you're not retaliating against them for bringing that complaint, or even retaliating against somebody who participates in that investigation of the complaint. So just making sure that there is no retaliation.
That's a quick question.
Sure.
Just clarification, you said the reasonable accommodation. You said for disabilities, you have 15 plus employees. if you have somebody with a disability that asks for accommodation, you have to give it because, or you just have to engage in the dialogue.
Just engaging with
So
them.
in both of them.
In both
You have to engage.
Yep, you got it. Yep. And honestly, I mean, if you have an individual with a disability, you're gonna work really hard to find a potential way to accommodate them. But the reality is it may not be possible. It might be a financial hardship or it just may not work for the team. Safety and OSHA basics, the most basic fundamental requirement of OSHA is to provide a safe workplace for your employees. There are certain employers that are required to maintain OSHA logs and illness and injury reports. It's typically going to be in your higher hazard industries. They have a whole list of industries where these logs are required. Typically, like office environments are not going to be on that list. There are certain things that do have to be reported regardless of who you are industry-wise. So if you have a death on your property, that is a reportable incident. But your typical, just kind of everyday workers' comp injuries, those kinds of things, don't have to be reported if you're like in this environment. But if you're on a high hazard industry list, you would have to do that. It's your responsibility to train employees on hazards. I was just yesterday working with a client on their hazard communication plan, which seemed kind of silly because they work with two chemicals. They have like a fertilizer that they use, and they just use fuel for their vehicles. But OSHA says that you're supposed to have a hazard communication plan that basically identifies like, how are we going to train our employees on the hazards that exist in the workplace? How are we going to make the information available if there's an incident as to what to do if you get exposed to those chemicals, those kinds of things. And then documenting workplace injuries. So whether or not you are an OSHA required workplace for reporting the incidents to them, really important to document your workplace injuries. If for no other reason than for workers' comp purposes, you want to make sure that those injuries are well documented, that you have a witness statement if that's available. Your workers' comp carrier is going to be looking for that information to be able to determine if it's a covered claim or not, and to really be able to help you through that process of getting that employee back to work. Leave laws, there's nobody in here with 50+ employees. Once you get to that 50 employee level, you are required to offer what's called the Family Medical Leave Act, which at its core is providing up to 12 weeks of unpaid job protected leave for somebody who's had a baby, had a surgery, lots of different medical conditions. What I would say is lots of employers offer leave of absence policies that look a lot like FMLA, but maybe don't necessarily offer the same protections, right? So if you're like a team of 5 employees, it would be very difficult in most cases to say, we'll hold your job for 12 weeks like we would under FMLA. But maybe you could have a leave of absence policy that says we can provide up to 6 weeks or up to 4 weeks or any variety of things. I think leave of absence policies demonstrate as an employer that you care about your staff, but you also want to offer things within reason given the size of your staff. We talked about the ADA with 15+ employees. Sometimes leave is an accommodation. So this is actually really relevant to this group. So because you don't have 50+ employees, you don't have FMLA, right? But you may have to actually offer leave as an accommodation under the ADA. So maybe somebody has a condition that would otherwise qualify them under FMLA. But because you're not over 50, you may have to offer them a brief leave of absence under the ADA as an accommodation. So just kind of be aware that it does actually apply at 15+ employees, which again doesn't currently apply to anybody in this room. But once you get to that level, again, just recognizing that the ADA isn't just about physical access accommodations or schedule accommodations. It could also be giving somebody a brief leave of absence because of the risk. State and local paid sick leave really hasn't hit us here in Pennsylvania. I think with the exception of maybe Philly and maybe Pittsburgh, but many states have started to require employers to offer paid sick leave and paid family medical leave. Might be coming at some point to Pennsylvania, but it's important to know if you operate in other states, not just with leave laws, but just any laws in general. It's important to know the laws of those states because they do vary state to state. Obviously, there's federal employment law that covers across the US and a variety of things, that each state also has the ability to enact certain standards. This one might surprise you. Military leave applies to employers of all sizes. So if you have one employee and you have somebody who's called up for military leave, you do have certain obligations under what's called USERRA, USERRA. It does not require you to hold a job for the person, but it does allow for reinstatement rights. It does allow for some opportunity for them to keep their benefits for a period of time. There's a whole list of requirements for somebody who goes on military leave. So just be aware that that applies to all employers. And the last one is if you have W-2 employees that are earning or accruing paid time off, vacation time, those kind of things. When somebody terminates, you may or may not have to pay out their balance, right? And I know it's going to seem funny, but in Pennsylvania, the term earned means something very different than accrued. So if your policies, when it comes to paid time off, talk about earning PTO, typically in a termination situation, because your policy said earned, you're going to have to pay out that time, okay? Mm-hmm. If it says accrued, like paid time off is accrued throughout the year, that means that you do not have to pay it out unless you so choose to do so. Most employers will pay out at least a portion of paid time off, but small words like that can really make a big difference in your policies as it relates to benefits that have to get paid out. So just be careful with that. Terminations, sometimes I hear people say like, well, we're employment at will and I can fire anybody I want to. And that's true. You can fire anybody that you want to, but oftentimes that's going to come with implications on the back end, right? And I don't think anybody in this room is like, I'm just going to go out and fire somebody today. Usually you have a pretty good reason to do so. But just be aware that just because employment at will exists, it's not perfect. It's not a get out of jail free card. You might end up with an unemployment claim. That's a very low end of things. You might end up with a discrimination claim. At the very least, you could end up with some bad social media if the person gets on Glassdoor and bad mouths you. So it's really important to kind of think through your termination decisions before you make them. And a lot of it has to do with how you've treated that employee leading up to that termination. Like, have you prepared them for that? Has there been progressive discipline? Have you done coaching and counseling? Did the employee, when they sat across the table from you, did they know, this probably wasn't me my way? Or were they like, oh my gosh, what just happened? So ensuring consistent treatment, documenting performance issues, reviewing for risk, following your policies. One thing I would typically say is that if you're going to have policies, follow them. Now, I talked before about having some flexibility with those policies, but in general, follow your policies. It's probably better to not have policies than to have policies you're just going to sort of ignore as you implement things. And then the last thing is COBRA. So when you are letting an employee go, now again, this is only for W-2 employees. When you're letting an employee go and they have benefits, you are required to offer them continuation of their benefits coverage under something called COBRA. So that's over 20 employees. There's also something called mini COBRA for employers under 20 employees. Basically, the same opportunity exists where the employee can continue their benefits at their own cost. It's typically a shorter time frame. So whereas COBRA for the 20 plus employers, you can go for 18 months. In Pennsylvania, the mini COBRA is only 9 months. So just being aware of like what you have to offer to employees as they're separating the organization. Layoffs and restructuring, there's something called the WARN Act. Now this really depends on the size of the organization. Nobody in this room is going to qualify for this, but basically the WARN Act, if you're of a certain size, you have to provide advance notice, you have to do public disclosures around what's happening. Obviously, if you're going to be doing a layoff or a restructuring, whether it's a large team or a small team, you want to be thinking about discriminatory impact. So kind of looking at who's in your group, how are you making your decisions? Is there any potential that if somebody on the outside were to look at this, would they say, oh, there was some discriminatory intent here? Or did they have valid job-based reasons for why we let this person go and let this person stay? When you're terminating, layoff, restructuring, otherwise, you want to make sure that you've got talking points and written documentation. What I would say in general is sometimes I have, when I'm sitting with supervisors and doing terminations, sometimes you want to go into a lot of detail. Sometimes you want to say like, I really didn't want to have to make this decision, but we're making this decision, less and more in those situations, right? You want to be able to articulate the reason why you're letting them go. Again, whether it's a layoff or a performance termination, you want to be able to articulate that, but to get into a whole monologue about it is not helpful, right? Because at that point, the decision has been made. And the longer that you talk, the longer that they're going to want to talk, and you end up in a dialogue that's going to still have the same outcome. So less is. And then handling final pay and benefits appropriately. We talked about the COBRA there. You want to make sure that if somebody is leaving your employment, that you're paying out their last paycheck timely, that you're paying out that PTO based on your policies and those kinds of things. So just a couple of just general thoughts to kind of wrap up here. So if you don't have a handbook, I highly encourage having a handbook. I can help you with that if you're interested. Conducting periodic policy reviews. The reality is like things change, especially as your organization grows. Like you might want to offer some different things, or you might realize, oh, we need a policy on artificial intelligence, or lots of things change, right? So kind of looking at your policies over the course of time. Training your supervisors in any of the things that we talked about. Obviously, reaching out to your legal counsel when you're unsure about something. I'm not a fan of calling legal counsel for everything. Obviously, if you have an HR person at your disposal, that's a good kind of first stop. But sometimes you need that legal consult just to be sure that what you're doing is appropriate. And then establishing a documented complaint procedure. I think it's really important in a handbook or just as a standalone policy to have some sort of complaint procedure in place so your employees know if they have a concern or a question, whether it's something really small or something big like an ethical concern, that they know exactly what it is that they should do to elevate that concern with the organization. I think that's an important thing. Key takeaways: document everything, invest the time to create and implement clear policies and training, and when in doubt, ask for it. So as I mentioned, I'm with Rooted HR. We work, I always say we, it's me. Over time, we hope to become we, but we work with primarily small businesses and nonprofits. And happy to come alongside and assist you with anything kind of in the HR space. So if anything today, you're like, oh my gosh, we're totally messing this up, or it's kind of sparked some things around, we probably should be looking at these different things. Happy to chat with you about that. No obligation. If you have any questions after today's session about anything that's kind of come up for you, happy to engage in that dialogue with you, and we'll kind of do it from there. So that's what I have for you today, Karen. Yeah.
Question, like as far as the HR consulting, have a guy. But is that something where it's like you're like you would connect with somebody and it would be a consulting for like ongoing, or is it based on event, or I guess there would be multiple opportunities?
Sure. It's both eight. So I have some clients where I just do a standalone project, like maybe you just need the employee handbook, do the handbook for you, and kind of in it. I have other clients that they call me as they need me. So I have one client where she had a couple situations come up in the past couple months. She picks up the phone, she knows she has somebody to call, she calls me, we kind of work through it, and that's it for them. I have others where I essentially become your HR person. And we decide like what's the appropriate amount of time per month. Maybe it's only 4 hours a month, maybe it's 2 days a week. I mean, it really depends on what your needs are, depends on your size. And that's more like a retainer situation. So it really kind of depends, and it's customized to your needs. It could be, project as needed or ongoing also. Is there a question over here too? No.
I have a question.
Yeah.
We never do a schedule call, but also I just have a general question that might be good. When you have a slide that line of two policies that you can have. Can you speak to can you have any policies regarding anything social media, any of that?
Yep.
How can you have policies in that regard that don't conflict with amendment rights?
Free speech.
Yeah.
Yeah, so there's various, it's a great question. Social media policies have definitely evolved over the years, because you want to make sure that you're not infringing on something called the National Labor Relations Act, which basically allows employees to discuss their terms and conditions of employment, their working conditions, those kinds of things. You also don't want to interfere with their free speech, but there's definitely specific verbiage that we could put into a social media policy that talks about, here's how you represent yourself, given that you are connected to our company, especially if you're gonna, be on Facebook and it says Drew, and what's your company name?
The day one.
Okay, and it says like your company name, but then you're out there like making a bunch of politically offensive posts.
Yeah.
So yeah, there's definitely some things we could put in a policy to help protect you, but also put some parameters in place to say like, these things are appropriate, these things are not. Yep, absolutely. Good question. Social media, it's a blessing, like universe.
Well, thank you,
All
Nate.
right, thank
It's
you.
very informative.
Thank you.
There is pizza and salad provided by Nate, in the coffee room. So if you are hungry, feel free to grab some. It's there for you.
Thank you.
Thank you very much. Enjoy the rest of your day. And thank you to Michelle for clicking.